Hey everybody, welcome to the last lecture of the semester and of your MDP year of incredible fun in the world of global pandemics. Um, Today what we're going to be doing is talking about software, intellectual property, a lot of the different legal things that are associated with the work that you do either at your company or the work that you've done here at U of M, and talk about the different ways that you can protect your intellectual property. All right, these slides came from a guy named Drew Bennett who works over at U of M's tech transfer office. At least I think he still works there. I haven't seen him in a couple of years. But he used to come to our class and actually give this lecture. But then I got comfortable enough with it enough so that I could do it on my own. But, anyways, um, what we're first going to do is we're going to start off with just sort of the basics of what you would see. If you were actually going to go through the legal process of protecting software that you've written. As you can see in this diagram over here, there's a lot of different steps that go into what you need to do to get your intellectual property protected. So you have to have things like agreements, and these can be agreements such as non-disclosure agreements where you agree usually to not talk about or tell anyone about what you're doing or what you're working on in the software. Other things about, like in the upper left corner, there's sponsored research agreements. If your research is being funded by like a government organization, generally you have to, if you're the project investigator, the PI, you generally have to take care of working with those agreements because you have to agree who's going to work on the project, how is the money going to be spent, that kind of thing. There's also things like term sheets and management plans that you have to deal with. Term sheets are if you want to take your software public, how are you going to make money off of it, that kind of stuff. There's license agreements, tech transfer agreements, all those different things like who's going to be making the money, how is the money going to be made, that kind of stuff. It's actually a very only small part of this whole process that really applies to the research and the development side of things. Most of it is legal. And for the most part, it's there to keep your interests protected so that you don't lose money when you go out and release your software and everybody starts using it and potentially could steal your information. It's really easy to do that with software. It's if you get access to somebody's source code, it's super easy to just copy and paste it. You've probably all seen that happen all over the place and not just in your classes. All right. So, unfortunately, a lot of this legal stuff sounds like the wah, 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 wah teacher in Peanuts cartoons. It's really hard to understand these things. Generally, people will have an entire department if they're at a big company that's devoted to just doing legal stuff. If you're at a smaller company or a startup company, you generally hire an outside legal firm to deal with this. It's very rare that you actually have like a single individual that is doing their own intellectual property work. Okay, so let's move on. So, like it or not, if you're writing software, at some point you're going to realize that you are in the IP and the legal business, and that you're going to have to start taking some of these things into consideration when you're working on software, especially if you're working on software with others, like other people that are contributing to the work or to the team or to the software, whatever. Okay, so like it or not, you're going to be in the legal business somehow if you're working on software. All right, so first off, I want you to understand a couple of things about what we're talking about here. First off, I want you to understand what you own and what you don't. The basic rule of thumb for this is that if you are getting paid for what you're doing, generally you don't own what you're working on. Okay. So in that situation, it's typically your employer that will own the software. However, if you are not getting paid, if you're doing something for free, generally that kind of stuff is going to be your own intellectual property. Okay, as long as you're not violating other legal agreements. So you can't, for example, work at Microsoft and then go out and create your own operating system, because it's more than likely that you would have signed some sort of an agreement that said, they're referred to as non-compete clauses, where essentially you can't use the knowledge that you're gaining at your job to compete with your job, right? So it's a non-compete clause. All right, so anyways, so this as you can see in the slide right here, it can also include if you're using the resources of your employer off the clock. So even if you aren't doing something that's technically connected with the stuff that you have at work, if you go home after work and you take that Microsoft laptop home with you, if you do any software development of your own that you want to make money off of, or license to other people independent of Microsoft, if you're using Microsoft's computer to create that stuff, they can make a claim on ownership of that property. So be very careful about those kinds of things that you do. The same sort of thing applies to me. If I wanted to go out and create my own stuff, my own apps, my own programs, whatever, and then sell them, but I used my U of M laptop to create that material, U of M could stake a claim on the work that I did using their resources. All right, so just be careful with that kind of stuff. Another thing to consider is how does this impact undergraduate versus graduate students? If you apply sort of this rule that I mentioned right up there about if you're getting paid, you generally don't own your IP, or if you're getting paid to create it, the same sort of thing happens with undergrads versus grads. So undergrads typically are not getting paid for the work that they do. The work that they do is part of a class. In fact, you're paying us, your instructors or the university, to teach you, and then you're using that knowledge to build something in the class. All right? So you're actually in a sense here, you're sort of our boss, right? Like you own the stuff because you're paying us to, with your tuition dollars or whatever. However, when you go to grad school, a lot of graduate students do what's called sponsored research, or they're grad student research assistants. And in that case, they are getting paid to do research by their advisor. This is especially true for PhD students, right? Master's students, it's a lot less, but PhD students typically are getting paid somehow. Right? So if the work that they're getting paid for is funded by some sort of a grant or through some university government agency agreement, typically the grad students are not going to own any of that IP. And if they want to make some money off of it, then they have to essentially spin off the work that they did and go through a group like the U of M Tech Transfer Office. All right. So in order for you to avoid all of these things, it's always good to figure out what you need to do in advance. Figure out what do you own, what don't you own, so that any development that you do in the future is very clearly delineated as to whether or not you can claim it as your own. Okay. Let's see here. Moving on to the next slide. So there's several different IP types that we're going to talk about. We're going to spend a little bit of time talking about service marks and trademarks. Those are roughly the same thing, and you'll see the example of that in a second. Then we're going to talk about sort of the big ones: copyright, patents, and trade secrets. Okay, and we're going to go in that order. So the first thing I want to talk about are service and trademarks. Now, back in the day, when these things were first sort of introduced, there was a difference between service marks and trademarks. In fact, if you want to watch a really hilarious video, there's a video link right down here. It's basically like, it's only like 2 or 3 minutes long. It's really short. It's basically, what would you do if you had an attorney and you mixed the attorney with a used car salesman? That's the guy talking on that video. It's kind of funny. But anyways, he does do the basics of describing the difference between service marks and trademarks. All right. And the main difference here is that trademarks are essentially a superset of service marks. Trademarks can cover both physical products, but they can also cover services. That's what service marks were originally created to cover. So a service mark is basically like a company that produces services. So like LinkedIn, for example, is a service. They don't have physical products. I mean, they might have marketing merchandise, but generally you're not buying that, right? You're paying for a service. So other things like Windows, Azure, you can see a list of them up here, Netflix, Dropbox, Google Drive, those are all services. And so their little icons or their little things that are associated, that's what the mark part of this is it's like essentially the branding icon. Those are technically service marks, but they're actually covered by the term trademark. So trademark is pretty much the term that's used exclusively now to indicate goods that are either physical goods or services. Physical goods you can see down here in the list here. These are more obvious things. So like Kodak and Polaroid, they have fanciful trademarks. The words were invented to cover the company, right? Like what was Kodak? I don't even know where Kodak came from. Then you have arbitrary service marks, so like Dove. It's not a fake word. It's a bird, right? But it's a soap company. They sell soap, and Shell and Apple, right? They're arbitrary. They have a real common meaning, but not in the context of the company itself. And then you have suggestive trademarks. These are ones that are named after something that's characteristic to the company. So like Jaguar is a fast animal, and Microsoft has software and micro whatever inside of it. Netflix has internet and flicks as in like movies. Then you have descriptive trademarks that are sort of one step less fanciful, I guess. So Sharp and British Airways and Best Buy, right? Although Best Buy isn't really a Best Buy anymore, but whatever. And then finally you have generic trademarks down here that have become so commonly used now that people just associate the trademark with the product. So can you pass me my thermos, right? Or give me a Band-Aid, I have a cut, right? Band-Aid is actually the trademark for the company, but Kleenex is another one, and aspirin, right? The trademarks have become so commonly used that they're synonymous with the products themselves. So anyways, the important thing to note here is that trademarks are these, different types of marks or icons, labels, whatever. They have different types of distinctiveness, as you can see in this list here, and trademarks are essentially a superset of service marks, right? Service marks are meant to talk about services, and trademarks are goods, but that's not really the case anymore. Okay, so the next thing that we're going to talk about are copyrights. And copyrights are generally used to protect things that can be like essentially put down on paper. All right. Anything that can be put in a tangible physical form is protected by copyright. And you don't even have to apply for copyright. Okay, if you write something down, or if you create a piece of music, or you make a little YouTube video or whatever, if you express them in some sort of physical form, a copyright is going to protect your authorship of that material, unless you create it under some sort of a license agreement that you gave away your rights or whatever. Or if you use like a web service, for example, that when you signed up for it, the web service had a little thing that you had to agree to that said any content you create on here is the product of us. All right, so keep that in mind if you care about owning a piece of work that you put in a physical form so that you can sell it to others. Like if you write a book, for example, make sure that you read all of the legal fine print that's associated with the materials that you're using and the technology that you're using to store that and create that, because you don't want to give up your rights. Now, the duration of a copyright depends on a couple of factors. If it's created by an individual, individuals have protection of their copyright for their lifetime plus 70 years. So if I were to create some, protected work, if I recorded a song that I wrote, or I wrote a book or whatever, I would be able to exclusively hold ownership of that content as long as I put it in some sort of a physical medium until I died, and then plus 70 years. So my family could rake in the profits, so to speak, if it was a successful piece of material. The next one down here, if something was created anonymously, pseudo-anonymously, and for hire, the protection there is 95 years from the date of the publication, or 120 years from the date of creation, whichever of those two things is shorter. All right. Typically, well, it depends. Like authors generally have individual copyrights. And then like a music company, for example, if they hire a musician for their record label, and the musician records songs for them, they're doing it for hire. All right. And so the protection for that is a little bit longer because it's connected with, a company, and the company is going to essentially live longer. All right. Next one the next protection that you can use for intellectual property are patents. Okay. And as you can see up here, it's a limited duration relating to an invention. It's granted by a very specific institution, the USPTO, the United States Patent and Trademark Office. And they grant you this essentially as a trade for you publicly disclosing the invention. All right. So a lot of times it's good, sort of in the general world of science, for example, to publish the results or to publish the way that you create something so that others can use it to help, either create new products and license that technology from you, or it's also a form of protection because you can actually file a lawsuit against somebody that's infringing upon your patents. All right, with a copyright, it's different than with patents, because patents have this formal process where you have to apply for a patent and all that kind of stuff, and it has to be granted. All right, we'll talk more about what goes into a patent here in a second. So you can patent things like machines, like a car, for example, or a widget inside of a car, a piston in the engine that your company spent years developing, and you're going to patent that so that no one else can have that technology. Other things like manufactured articles, you can patent an industrial process, you can patent new chemicals. Patents have a lot shorter duration than copyrights, though. And we'll talk more about copyrights versus patents with respect to software in a little bit. All right. So a design patent. So this is something that you haven't necessarily built or anything. It's just a design. That's 14 years. The time for a utility or a plant patent, believe it or not, there are actually patents for plants, different strains of plants. So like, ooh, I made a new kind of corn, so I'm going to patent that. Well, okay, so you get a plant patent. Those are for 20 years. Now, the major difference between all these different types of patents, I'm actually going to put a little YouTube link here for you to click on in the PowerPoint. Give that a quick watch. It's very short, just like the other videos that we've had on here. And it describes sort of the main differences between design, utility, plant patents, all that kind of stuff. All right, so what are the considerations that the USPTO has to, take into account when they're looking at your patent application? First off, it has to have eligible subject matter. So in other words, you can't do things like try to patent a law of nature. All right, you can't be like, oh, I'm going to patent general relativity. Nope, sorry, that's a law of nature. You can't patent natural phenomenon. So like, ooh, lightning, I want to patent. Nope, can't do that. You also can't patent abstract ideas, right? Design patents are probably about as abstract as you can get, but a design patent actually has to discuss the different elements that go into a design. It can't be super abstract. So the patent auditors, or whatever they're called, that work at the USPTO, they have to first make sure that your patent has eligible subject matter. The next thing is it has to be new or novel. Okay, it can't be something that has essentially been invented before. It can't be just like oh yeah, I took a cup and I put a grip on the handle. I mean, like, maybe you could patent that, I don't know, but it has to be new and it has to be novel, right? It can't be just some like ridiculous addition to something that's already there, or like you can't like take a coffee cup and then put like a star on it and say, oh, I'm going to patent that, right? It has to be a new and novel invention. And again, this is really up to the patent examiner. I think that's what they're called, patent examiners, not auditors, to decide if what you have is eligible subject matter, is new and novel, and then finally it has to be unique, non-obvious, and of basic utility. Okay, so non-obvious is one of those things that's also a little bit subjective, where you can't patent something that's obvious. And I really struggle to come up with an example for this, and I try not to come up with examples when I'm doing this lecture because I'm not a lawyer, all right? But that's basically how it works. It can't be something that's obvious when you look at when you look at the patent. If someone was just walking down the street and they're like, oh yeah, I do that every day, that's probably something that's obvious. All right. Now there is something down here at the bottom. There was a lawsuit just recently in the world of law, so 6 years ago, that said that simply implementing an idea with a computer is no longer substantive enough to be patent eligible. So if you use a computer to do something, that's not unique or novel enough to warrant a patent. Okay. So anyways, that leads us to the next slide, where we talk about software IP contributions. Okay. So here's another little link right here. This is kind of it's a link that does talk about software patents and a very brief history, but it is kind of an ad, right? It's by a guy. He calls himself like the patent professor or something. He has a company that does software patents, and it's kind of an old video, so who knows if they're around anymore. But The too long didn't read type deal of the whole thing is that software patents are generally really hard to get. They're really hard to understand. And if somebody violates if they infringe on your software patent, it's hard to enforce that. Okay. For a variety of reasons, one of which is probably that the legal establishment hasn't yet caught up intellectually to what software is and what should be or should not be protected by a patent. Okay, so generally when you're working with software, you're not going to try to apply for a lot of patents. Instead, what you're going to do is you're going to operate under the realm of what are called trade secrets. And so that's what's on this slide. Okay, so trade secrets are pretty much any secrets that you create at your job that you don't want anyone, especially your competitors, to find out about. So this could be like formulas for a chemical reaction. They could be patterns for the inner workings of a design. They could be devices, methods, programs, all sorts of things. The key with these things is that you keep it secret. You don't want people to find out about it. So Apple is sort of notorious for doing this with their hardware. They'll build like a special chip that does something, and they won't tell anyone what that special chip does. And so if that chip goes out on your motherboard in your laptop, for example, you can't just go down to the corner store and buy a replacement chip from some random manufacturer. You have to buy that chip from Apple, and Apple might not even sell the chip. Okay, so what that does is it makes it really difficult for individuals that do repair on things like MacBooks to find replacement parts. So if you had something as simple as like a USB 3 chip or a USB-C chip controller or something on your motherboard, if that thing got fried, the only way that you can get a replacement part for it would to either get one illegally that violates, trade secrets, like somebody reverse engineered that chip and figured out what it does, or you find a donor motherboard and you pull the piece off of that and then you put it into your motherboard. All right. Now that doesn't mean that everything that Apple sells is protected by these trade secret chips, right? Like the port for a USB-C, for example, is not Apple's trade secret. It's a standard, actually. So if your port on your iPhone, for example, breaks, you can go out and buy a new one. You can buy a new screen for your iPhone if you crack it, those kinds of things. But there are some parts of Apple hardware that are protected by trade secrets, and that's just it's not necessarily good or bad. It's just the way that they have decided to protect their intellectual property, and it's the way that they've decided to make profits. Okay, you make more money that way if you have your own design that you protect via trade secrets. All right, and so trade secrets, by the way, these things are typically kept safe through things like non-disclosure agreements, where you sign a legal document somewhere that says, if you tell anybody how this thing works, we're going to sue you for ungodly amounts of money, especially if the secrets that you reveal take away a significant portion of our business, right? Okay, so now let's talk a little bit about a different way of releasing software, and that's via what's called open source software. So as you can see here, open source software is essentially software whose source code is made available openly so that people can look at it. And the copyright holder, which is usually, like the Electronic Freedom Foundation or whatever they call it. Where is it? The Free Software Foundation right there. They're going to generally have some sort of a, stake in these types of licenses. And basically what it does is it allows people to create software in a collaborative environment. So here's a little slide that I pulled off of TLDR Legal, and it gives you a quick summary right here in the middle of what open source is. It says you can do what you like with the software as long as you include the required notices. This permissive license contains a patent license from the contributions of the code. Yeah, I think I read that right. All right, so anyways, there's a list of things down here in these boxes that you can, cannot, and must do. One of the big things that you must do when you use open source software is you must include the copyright and license You must state any changes and then have a notice of this whole process in any derivative work. So if you take, the source code for some open source web browser or something and you modify it and then you want to release it, you can release it. You can even release it for commercial use after you've modified it. You can distribute it. You can sublicense it. You can do all of those things that you see over there on the left. But you have to include those licenses, okay, that says that it's open source software. What you cannot do is you cannot hold the copyright holder liable for any damages that are done by the open source software. And you also can't use use their trademark with it. All right. So anyways, those are the things to consider when you're doing open source. As I said, I'm not a lawyer. So if you are, especially if you're at a company, for example, like, Amazon or whatever, if you dip your toes into the open source software waters, make sure that you have a very clear understanding of what using that software means, especially from a legal perspective at your company. You don't want to accidentally use some open source software and then realize that you can't, you can't do something that you want to from a legal perspective with your software. All right, so that's actually the last slide here. Not a lot of stuff in here in this in this set of slides. The main things to take away, right, are the different ways that you can protect your intellectual property. So via patents, copyrights, trade secrets, that kind of thing. One thing that I did forget to mention about software specifically is that software really is not protected by copyright. Okay, you might think that it is, right? If you write down your source code and then you print it out, yeah, that specific source code is technically protected by copyright, but it's only protected in the actual form that you printed out. So if you go in and you change the code, it's no longer protected by the copyright until you essentially put it into that physical form. So that's why software patents, if you do want to sort of license software to others, you're not going to do it via copyright. Okay, you have to go through the process of getting a software patent. And as I said before, software patents are difficult to get. They're hard to manage. They're hard to enforce. And so generally when you have software, it's just going to be protected via trade secrets and all that kind of stuff. All right, it's very murky business. If you step into the software patent waters, and it's also murky when you're dealing with trade secrets because you have to write up the appropriate legal documents that you have to then get people to sign. So anyways, it's all a lot of lawyer stuff, but it is important to have that out there because it does protect your interests. And believe it or not, people actually do steal code. All right. It used to be a lot more prevalent back in the day when you could just stick a CD in and copy it onto another blank CD. But yeah, anyways, that's that. One thing that I do want to mention is that next week is going to be our exam. The exam's format is going to be essentially identical to the type of format you had in the first semester when you guys were working in sync with EECS 497. So it's going to be a mix of multiple choice, short answer, and some essay. As far as like how much time you're going to have to do it, probably going to be the exact same. I haven't yet written the exam, but I suspect that the exam will be, written to take anywhere from an hour to an hour and a half max. However, you will be given 4 hours to complete the exam once you start it. And I'm probably just going to give you like a 48-hour window during which you can start and finish the exam. So basically next Monday, I think it's the 7th of December, you'll be able to start the exam. It's almost exactly 2 weeks from now. So I'm recording this. It's 3:30 p.m. I'm about to jump into office hours. So you can essentially start the exam anywhere from 3:30 p.m. on the 7th of December, and then you'll have until 3:30 p.m. on the 9th to complete the exam. So make sure that you start it in time so that you don't hit that 3:30 or go over it. Anyways, I'll put all this in an announcement on Canvas. I just wanted to shoot it out there for you if you'd rather hear me talk about it. And with that, that's all I got. So good luck on the rest of the semester. Good luck next semester if you haven't graduated yet. And I'll see you later. Bye-bye.